So when you take a loan, we want this loan secured. We want it secured. So one of the things I'm going to look at is the legal process. What is a charge? So in simple language, this is a legal document prepared by a lawyer to register an interest in the property. And this document called a charge actually creates a security that is enforceable against United Women's Circle or any other third parties. And this charge document is actually to protect the money that the circle has given to you. So there has been a confusion about what a charge vis-a-vis a transfer is. So a charge document does not transfer the property into the name of the circle. What it does, it's just to create an interest on the loan in favor of the circle. So it does not transfer. The property is just merely registered in the joint names of the circle and a member and discharged later. Now we have two types of charges. We have what is called an informal charge, which is provided for under the law, that is the Land Registration Act. And what does that mean? It means that you can actually deposit a title. It's by simple deposit, but I want to clarify that this is not applicable to United Women's Circle. Much as it's provided under the law, the circle does not do informal charges or simple deposits, as we call them. So then there is what is called a formal charge. That is where now you prepare a charge document that is registered and the interest of the circle is secured. In a formal charge, you may have a title that is in a person's name. So that is where the owner is also is the same as the borrower. And we also have what is called third-party charges. So third-party charges is where the owner and the borrower are different. I'll give an example. Anne has a title, but she's not even a member of the circle, but the person borrowing is Nancy. So Anne gives Nancy, who is a member, the title and guarantees that loan. That is what we call third-party charges. In our lending policy, rather, in the circle, we have exactly what you can charge. So these are shares at NSC. You can have logbooks for private motor vehicles. Please don't bring a logbook for a matatu or a lorry. That shall not be accepted. And then we have property titles. So let's look at shares. So this will be shares that are trading at the Nairobi Securities Exchange. And members at times have brought certificates for land. These are not acceptable because they cannot be enforced. Then the shares are up to the 50% of the current market value. And what you will be required to provide is a current CDS statement, duly filled CDS pledge form, and letter from the CDS confirming pledge of shares to United Women's Circle. Then we have logbooks as security. And as I said, this will be for private motor vehicles only. So a member can use a logbook as security for a loan up to the extent of 70% of the current value of the vehicle. And the vehicle shall not be more than 10 years. Going forward, it will be a motor vehicle that is 5 to 6 years. Logbook in member name. What will you be required to provide? So you'll have an original signed vehicle logbook in your name, KRA blank vehicle transfer form, duly signed to effect the change of ownership in the joint names of yourself and United Women's Circle. Then you'll have a valuation certificate from the Circle recommended valuer and a photo of the vehicle. So the Circle will not allow you to just go out there, bring a valuation from any valuer. They have valuers in their panel, and you can only go to one of them. Then you also have proof that that motor vehicle is comprehensively insured. So they'll also require a certificate to show that that motor vehicle is comprehensively insured. Then a letter from your insurance company confirming that the interest of the SACCO has been catered for. And then lastly, you'll be advised by the SACCO how much you need to pay to transfer, to register that logbook in the joint names of the SACCO and yourself. So there are times you have a logbook in the name of your company as opposed to yourself. Again, these are the documents you require. You'll require, again, a logbook, a KRA a transfer form, a copy of the PIN certificate for the company, director's PIN and ID, certificate of incorporation for your company, and CR12 to confirm company's directors. So you'll not obtain a CR12 unless you have paid your returns for the company. So we have two types of titles to properties. We have what is called a freehold title. I don't know how to say that in a layman's language. It's just called a freehold title. But to explain it in a layman's language, these are actually titles that are held in agricultural areas. And it's called a title deed in simple terms. And you'll find that it has some sort of red seal below. That is what is called a title deed. A leasehold is a temporary ownership of the title. You do not own it absolutely, because it's the owner is actually usually the government, and you own it for a period of 99 years, so that if that 99 years then expires, then you have either to ask for a renewal of that lease, otherwise the government takes it back if you do not ask for renewal of that lease. So when you're coming with your lease to the SACCO, what you need to look at is what is the remainder period. For instance, you're taking a loan for 15 years, but your remainder period in the lease is 10 years. So that will not be acceptable, because you'll have to, then it will not be valid during the existence of the loan. What you need to do is to bring a valid title. We know you're in Kenya, and at times we have fake titles. And this title can be either in your person or a company name, or even a third party name, that is the person who is guaranteeing you. You do not have a property, but the property that there's a property you're buying so as to be charged. So we also have that property that is actually under purchase. So if you want to use a property that is under purchase, please ensure that you have a valid agreement for sale. Because at times members go to the SACCO and they say, I want you to secure this loan. They have even paid a deposit, but they do not even have an agreement for sale. When I say a valid agreement for sale, make sure that it has workable completion periods. I've seen members who go and commit themselves to complete a transaction within 7 days, and they go to the SACCO and say, I want you to charge this property. That creates a lot of problems, because the completion period, even in the agreement for sale, has already expired. So you have to go back to the owner and say, extend time. So please allow a reasonable completion period. And the only way you can be able to do this is to consult a lawyer who will look at the agreement for sale before you execute it, and make sure that the completion periods are agreeable, the terms are favorable, and that you'll not be caught up in non-compliance of the agreement for sale, where you even end up losing probably your 10% deposit. Then you also need to have that property valued by the SACCO. Again, it is by a SACCO recommended valuer, not your own valuer. And of course, this will be at a fee. I think it's a minimal fee that will be advised by the SACCO. And then if the land is agricultural, what I called a title deed, then you will require consent from the Land Control Board. So usually the best practice is to go for a special board, though this is cheaper. Of course, it's like minimum 1,000, but it's very costly, because you end up paying like 10 times, but you get your consent probably within 2 or 3 days. So a member has a choice whether to go to the normal board or to go to the special board. So that is your prerequisite. You choose where to go. I know during COVID, there was a waiver on consents to charge when it comes to leaseholds. But when you're financing, the SACCO wants to have a property that does not have any encumbrance. I don't know how to say an encumbrance. Does not have, what can I say? It does not have any debts. So make sure that you pay your land rent, and I would ask members to do this if you know that you're going to give your lease certificate or your lease document for charging. These are the prerequisite things you need to do, because we are saying that we are giving loans within a very short period. So if you go to the SACCO, then you haven't paid land rent, you haven't paid rates, and you haven't you've not got clearance and consents, then you see your loan is going to take a longer period of time. And like where there is you have probably a lease for your apartment, there is a requirement that the management will give you consent. So make sure again you have paid your service charges, and you have paid your water, you have paid your electricity, and all those other obligations that the manager requires you to give. Otherwise, the managers will not give you the consent to charge or to transfer. And this applies also to where you have a lease for an office block. The requirements are the same. Make sure that you pay your service charges, and you pay water if that is a requirement. So when you're preparing a charge document, you may also require to have prepared a personal guarantee and indemnity. So in a personal guarantee and indemnity, this is where the title does not belong to you, and this applies to what I call third-party charges, where somebody is giving you a title to charge. So they'll also need to give you a personal guarantee and indemnity. And for instance, where you are also taking a loan for maybe creation of rental incomes, we may also require you to execute what is called a deed of assignment of rental income, so that when you default, then the SACCO can actually come in and get that rental income to pay itself. Another thing that is very, very important, and which people I think find as a shock when they are coming to borrow using security, is that you must pay stamp duty. Usually, this is a 0.1% value of the loan amount that you are borrowing. And another thing I need to emphasize is that where a property is being purchased and to be used as security, you will now require also to pay stamp duty again on the transfer. So there are two categories. Where the property belongs to you, then it's only stamp duty on the charge that you are paying. Where you are transferring a property and charging it, remember that you have to pay stamp duty on the charge and on the transfer. So the stamp duty on the transfer will either be 2% or 4%, depending on the location of the property. So now let us come to the thorny issue of spousal consent. And the law provides that you will require to get a spousal consent where you are charging or even giving as a gift or transferring a property. So this is a creation of the law. It's not a creation by lawyers, as many people think. And the intention previously was to have matrimonial property. You secure a consent, a spousal consent only in matrimonial property. But of course, there were logistical problems, because the land registrar, from where he sits, is not able to tell which is matrimonial property, which is not matrimonial property. So what is happening now on the ground is that any property that is held during a marriage, whether this is where you're living or not, requires a spousal consent. And the problems that have been faced is, at times you buy a property, you do not tell your spouse that you have this property, then you want to use this property as security. It really poses a problem, because now you have to start telling your spouse, I have this property, and at times they are not willing to give spousal consent. So I think if you're in that scenario, please tell your spouse early enough, so that when it comes now to the execution of the documents, because your spouse must give you a spousal consent, then it doesn't pose a problem. So spousal consents are required twice. So when you're going to the Land Control Board, you require a spousal consent for the land board to give you a consent to transfer or to charge. When it comes to charging the property again, you'll also require a spousal consent. So who is a spouse? This is provided for under the Marriage Act 2014, and it says either a husband or a wife married under any recognized marriage regimes in Kenya, either in a Christian, civil, customary, Hindu, or Muslim marriage. So there is an obligation to the lender, in this case the SACCO, to make sure that a spousal consent is prepared alongside with the charge. In fact, what I'll tell you is that if you prepare a charge document without a spousal consent, it will be rejected at the land registry. So it's not a registrable document, and therefore this is a requirement when you're preparing a spousal consent. And then please do not bring us a fake spouse, because we have, I know this does not happen in United Women, but this is Kenya. You know, Kenyans can do anything. And what they do is, they can come to the office and, bring you a lady or bring you a man and tell you it will catch up with you, because you should know that this is a criminal offense. So bring your true spouse and the real spouse that you introduce to the SACCO. Or if you are newly married, please do not bring us a fake spouse, because it will catch up with you. So there are instances where members say that, why is my spouse giving me a consent and, he did not contribute to this, to the purchase. It does not matter whether they contributed to the purchase of the property. As long as you are married and you acquire a property during the subsistence of that marriage, it does not matter that he contributed or he did not contribute. There must be spousal consent. So I hope members, because those are questions that you always say, that why is he giving me consent and I bought it myself. The law does not know that. It just says that they must give you consent as long as it's a property that is acquired during the subsistence of the marriage. So the exceptions to the spousal consents, and this is where either you're divorced, in which case you will have to give us documents showing you are divorced, maybe a divorce document. If you are widowed, probably you'll give us certificate, the death certificate. And if you are a single person, you just simply tell us so, and then what we prepare is an affidavit. And remember that this is a declaration you are making to say either you are widowed and or you are divorced. And again, integrity comes in here. Please do not lie, because you'll be doing a declaration which is under oath. So if you lie, and one day your spouse comes and says, probably you're not able to pay this loan, and it's put up in the newspaper, and your spouse doesn't know about it, and they come and say, I was not aware of this loan. Remember, you did it under a declaration. It is perjury. Under the law, it's called perjury, and it's a criminal offense, and you'll go to jail. So please don't come and make a false declaration, because when you go to a lawyer, they are depending on the information, the integrity of the information that you give them. When it comes, I said that there are also third-party titles, and if, like for instance, a title is owned by a company, there are requirements that I've given there. This you can find within the SACCO offices. You'll require a certificate of incorporation of the company, a PIN certificate, pins and photos of the directors. And you also need to do a resolution to borrow, because the company directors must give you the permission, and the resolution to borrow will indicate the amount and the titles that you are giving, and you must seal that resolution. And then what you need also to know is that if a property is in the name of the company, after the registration of the charge, then that charge document is there's a further registration in the company's registry. And so that when you do a search in the company's registry, it should show that company A has a loan of this amount. So once you register it, again, it's at a fee. It will be assessed. It's not a lot of money. It's a minimum fee that is assessed. And then you get what is called a certificate of registration of mortgage. And again, I'll go back to the issue of company returns. Because we need to get a CR12, this is basically a search on the company after the registration of the mortgage. Then if you will not have done your company returns, again, the lawyer is not able to get the CR12, and again, this will again delay your loan. So if you look at the charge document, it's a big booklet. For those ones who have charged properties, you've seen what is prepared is a very big booklet. I know most of you don't read through it, but it has it has basically terms and conditions for this loan. It has members' obligations, it has members' rights, it has lenders' obligations, it has lenders' rights. So it's also good that when you go to sign this document, ask the lawyer to explain in brief what it is all about. And the only thing I look at in the document is remedies when it comes to default. Because at times we are excited to get loans, but we don't look at the defaults. So the defaults, the remedies will actually be contained in that charge document. And if you default, then a notice is given to you. And after 2 months, if you have not remedied that default, then the SACCO, of course, can issue what is called a statutory notice. After 90 days, then they go through recovery through auction. Even after auctioning the property, members, you need to know that if the SACCO does not recover all its money, then you can be taken to a court of law to be able to recover. So auctioning of a property is not the end of the story. If it does not recover the money, then the SACCO has a leeway to go to court and sue for the balance. Then the SACCO can actually lease your property. When you default, they can come in and take possession of the property, and or they can sell the charged property, or they can appoint a receiver to take over your property. So lastly, what members wanted to know, and this I won't go through, are the legal charges for when you want to charge a property or when you want to transfer. So what I would say is that these are not abstract members that lawyers come up with. The legal fee is actually guided by the Advocates Remuneration Order of 2014, and a copy can actually be available upon request. But what we have done is on the write-up, we have just actually categorized lease for charging and lease for transferring the property. And this I will not go through because they're in percentages, but you can just go through at your own time and familiarize yourself with them. In conclusion, members, this is what I want us to understand before you charge a property. Please understand the cost implications of charging and paying stamp duty and transfer fees, because there are times you come to charge and you go and enter into an agreement for sale, but you did not think about stamp duty, the 4%. So you're just thinking about the purchase price of 4 million. But by the time now you have the property transferred, there's 4% transfer. There's 4% stamp duty on the transfer. There's a stamp duty on the charge. There are legal fees. So please understand the entire process so that you know, even as you are borrowing, how much are you borrowing? If what you are borrowing is not enough, so do you have a fallback position for these stamp duties and registration fees? Please also understand that charging and transferring is a process that involves various offices. So start early. Start early so that also your loan is obtained seamlessly, and so that you do not have to call the SACCO every minute. You know, you're panting. When is this? Probably the person who sold you the land is really chasing you every day. You are having sleepless nights because of the completion period. So start early. So as I said again, those legal requirements or spousal consent, inform your spouse in advance. Then there's also something that is very thorny when it comes to payment of stamp duty. Now stamp duty members is paid to your KRA portal using your PIN registration certificate, and you have a password to that portal. It is only you who knows it. So because at times members do not know how to generate it, at times we request for that password, and at times it doesn't augur well with members. So we give you the option. Please generate an e-slip and bring the lawyer the e-slip so that they can pay your stamp duty, or provide the password so that we generate it for you. Actually, it's usually easier, and then you can change your password. So if you are called and asked to provide your password, please do not get irritated. It's just what we need to do. because it needs to be generated. The stamp duty, whether it's for 200 shillings, needs to be generated using your PIN certificate. So again, as I'll say, consult a lawyer before you sign any agreement or pay any deposits on a property transaction, because that will save you a lot of agony. Because the lawyer, of course, is able to do due diligence for you and make sure that the property that you intend to buy and probably charge has a proper title. Then we have another issue that members probably may not understand. There are those members who will call and say, I want to come and pick the documents and take to my wife to give a spousal consent. Again, that is not allowed. What we can do, probably if you're too busy, is to have maybe somebody from the office come to your office and then sign before somebody from the lawyer's office, because there is a verification saying that you signed before somebody. And when you take the document, we are not saying that you'll go and forge the signature, but we just want to be sure that it was signed by the proper people, and that is the legal requirement. So also understand the lender's remedies. I've already gone through that. And the most important thing is that once you charge that property, please pay your loan and pay it timely. And we do not want to also to take a security, because this is a property that you are unable to sell. That's where you're bringing. Bring us a good title as well.